before we do get started on the actual presentation, I did want to say a word to you all about CE and continuing professional education credits. So in order to receive the 3 credit hours, you have to be in attendance for both this meeting as well as the session on Friday, August 15th from noon to 2. I don't know if that was clear by the flyer, but that's also online, and we'll talk a little bit more about that at the end of the program.
So the first part of our presentation is structured like the small group orientation meeting we have for prospective clients at the beginning of our process. When a prospective client inquires about our firm and is interested in doing estate planning, we ask them to attend a small group orientation meeting in which we cover how to select and work with an estate planning attorney, which all of them have a problem with deciding how they're going to select an attorney and how to work with them. So if you refer someone to us and they come to a client orientation meeting, we wanted to give you the chance to see what type of introduction to estate planning we do, and that way you'll know what their experience will be. Alicia sent you questions for review prior to the meeting along with answers about how to select and work with an estate planning attorney. That thing that she sent to you has the answers on it as well. We give the questions to our clients in advance of the small group orientation meeting, and then when they come, they get a workbook with the questions and the answers as well. Now, understand that these aren't the questions that clients typically ask us. What these are the questions that they would ask if they knew what we know. It sets up to get the client in a situation where they can really evaluate an estate planning project, and so we can evaluate things, so they can evaluate things that wouldn't otherwise easily come to them and understand what their options are. So, Christine?
Oh.
Go ahead.
Yeah?
Go ahead.
Okay, great. So to start, many of you probably found there are really only 2 types of things in life, things that work and things that don't work. And this is what we talk to clients about. And in our opinion, most estate plans just don't work. And by work, we mean meet expectations. So if a client is creating a plan, then they have some expectations, and if we meet those expectations, that's a plan that works. Anything else that happened is a plan that didn't work. So the challenge in estate planning is that we have to figure out if the plan worked or not. So how do you know a plan worked and met an expectations? Or a better question is, when would you know whether an estate plan a little bit of feedback. I'm going to put you all on mute, but please feel free to type it in the chat box if need be. Okay, so like I said, when do you know whether an estate plan works or not? Well, we've developed the snapshot test, and we're optimists, so when a client's up on their cloud looking down, which beats the alternative, they're looking at the people and that they have in their lives, and they're all scurrying around after they've died. And if they're doing what they're supposed to be doing and not doing what they're not supposed to be doing, putting it plainly, that would be a plan that worked. So for a lot of people, that picture is a little bit fuzzy. So with some digging and some prompting during counseling, we found that with some help from professionals and a team, clients can develop that snapshot a lot better. So with a sport like archery, you've got a clear target, right? You have a bow and an arrow, you let it fly, and either hits the target or it doesn't. So how do you evaluate an estate plan? Well, it's important to know the target. So what's the target? Our mentors in the National Network of Estate Planning Attorneys have helped clients with that target by developing the definition of estate planning. So let us try this out on you. The definition starts like this. I want to control my property while I'm alive and well, meaning whatever I do with my plan, I don't want it to interfere with my control. And we never had a client that objected to that. So then plan for me and my loved ones if I become disabled. This is unfamiliar to most people, so the way we like to put it is the way that you would have done it if you could have done it yourself. Then give what I have to whom I want, when I want, the way I want, not asking for much, right? All while transferring my wisdom along with the rest of my wealth. So some people are usually just sitting there thinking, wisdom, I don't have any of that. But obviously in our experience, people are much more important and live bigger lives than they think. And what we mean by wisdom is that people usually have an opinion about certain life events that could happen. The point is, it's not just about the money. Wisdom is an important component of planning, and we believe a plan should reflect the client's wisdom and life experience. But of course, it's what the client believes that matters. So we've developed a philosophy over time that's embodied in this planning pyramid. We believe in starting at the bottom with the most important person in the world, which is the client, because that's who creates the plan. Spouses usually point to each other in a meeting as the most important person in the plan, because the reason why people do estate planning is they care about somebody else and they want to make a difference for family or community. But on an airplane, they tell you to take care of yourself first, put the mask on, then the loved ones. Obviously, it very quickly moves on to the family, because usually clients come in because they care about somebody else and they want to do the planning for that purpose. So the family's next, but it could say loved ones as well, obviously. And this part is the base of the pyramid. The next part is preserving wealth. So we find that people spend more time and energy trying to preserve what they already have, which I'm sure is your experience as well, than going out to get more. And a lot of times our role as the estate planning piece of the team is much more about preserving wealth than expanding wealth, which is much more the province of the financial advisor. So this is a team sport. There's a role for the client, of course, and a role for professionals. And if we can put it together, that's better.
Then we ask clients, well, what's the easiest piece in a puzzle? And this is something we have a little fun with. I understand that this has been asked to hundreds of attorneys by members of the network when they're doing training over the years. And what's really kind of interesting is that the professionals usually say something like colors or corners. But when we ask this question in our meetings, in our preliminary meetings, what we get from the clients is the last piece often, and sometimes we get the first piece. Well, you wonder why that is, and we think that it's because most professionals approach planning differently than we think should be done, and that is because we approach things as problem solvers. So if we're going to approach estate planning from the point of view of the taxes, which is the top of the pyramid, we're really putting the whole planning process upside down. Colors and corners are strategies that attack the jigsaw puzzle. Professionals see themselves as problem solvers, and the problem usually has to do with saving taxes. But we believe that we know the clients, and that we have to know the clients and their families first. And tax savings is like the last piece in the jigsaw puzzle. It's the other pieces that we have, that's the hardest part of the puzzle to solve. And that's what counseling is about. So who's the expert on the family? As compared to the professionals, we think the client is. So we make an agreement with the clients. You teach us about the family and yourselves and what you think, and we'll teach you about the law, and together we'll co-create a plan that works for you. In a normal interview, the professional knows little about the client and family. That's the attorney. So we tell clients to make sure that the attorney cares about who they are and cares about matching their goals with their plan. We were trained as problem solvers as well, but you can't solve a problem if you don't understand the questions to begin with. And if you don't know the background, that's a big deal. So that's why we have to start at the bottom of the pyramid and understand the problems that the clients actually see themselves and the things that actually keep them up at night. Christine?
So we like to focus on client goals first and find solutions to their problems, which makes planning easier. This exposes most estate planning as upside down, like we talked about, because planning usually starts with a solution like saving taxes before finding out the client's goals. And most of the time, the attorneys are focused on the documents, and most financial advisors believe the attorney's role is just to do the documents, right? So the debate centers around which document. And clients come to learn which type of document is better, and it's usually between wills and trusts. However, neither one of them is going to work for a really practical realistic reason, and that it's not about the documents. It's about the results the client wants for the family. So if a plan went through probate and met the client's goals, then that's a plan that worked. Same for a trust. What's left out of the debate between professionals is often that small piece that's all about the client. So I just want to make it clear, our plans are trust-based plans, but it's not about the document. A trust or a will is just a stack of papers, about who gets what. So a will may have a trust established after you die, which says, upon my death, form a trust, and your assets are moved after you die. The formal name is the last will and testament. But for us, instead of waiting for the person to die, we put the assets in the trust today, and the will is just a backup. We use what's called a pour-over will, which you've probably heard of, and it deals with any assets left out of the trust. We ask clients how many of them want to avoid probate. Most clients don't know why or how it works, but they know they want a trust to avoid probate. So there are a lot of ways to avoid probate, and a trust is just one of them. And we're a big proponent of avoiding probate, but we want to suggest to you that it's not the real goal. The goal is to produce the family results when the client is up on the cloud with a vision of what's supposed to happen. So we believe the keys to an effective estate plan are those listed here. First, in order to discover a client's goals, they need personalized counseling and have a great set of instructions. In most plans, you can take the front page and the back page off the document, and you couldn't tell one plan from the next. And we think a plan should be personal. So it's the personalized counseling that's the key. By the way, we do have spell check. Counseling is spelled that way to put emphasis on it. Anyway, so the second key is to an effective estate plan is we believe proper asset ownership has to be taken care of. So a huge key is owning assets properly so that the trust will, with the personalized instructions, actually controls the client's property. It's a boring job, it's not hard, but people don't pay attention to it because they don't realize it can make all the difference in whether a plan works or doesn't work. To be clear, proper asset ownership means the correct titling on a client's property, obviously. It's the position of the assets that determines what happens in the end. And Alicia, our client services coordinator, helps clients retitle assets into their trust full time to make sure the assets are in the right place. And we call this process funding. So third, we believe a formal review process is a key. The need for a formal review process is the documents get challenged by changes. So even if on the off chance a client had a customized plan that held up after 10 years, that would have to mean that they also didn't change one single asset in that time for the plan to work, with a myriad of other things. So the key word is formal, because the bottom line is that most people don't review their plan informally. Most people have a life to live and important things to do. And you'll hear from clients, oh, we'll review the plan later, and later never came. So we believe it's important to be a part of a formal review process, which we have. Fourth, let's say we magically achieved all three of those prior keys. What you'd need in order to control the cost element of the plan is a controlled transfer process. So when a person dies, it goes to the right people. And at our small group orientation meeting for clients, we ask them, how many of you, if you died tonight, think your family would be prepared? And rarely do people raise their hand, but if they do, we ask them, to define what prepared means for them. And most people in our experience say that the family knows who the attorney is, and that's being prepared, or they know who to call. So as you know, most clients choose family members as helpers, which is our word for trustees, personal representatives, and so forth. So they choose family members as opposed to a professional. And most people who are not professionals, if they know what to do, how to do it, and how to pay for it, they would be prepared in our mind. So we also ask people, how many of you have talked to the attorney about your estate plan and how it will be charged after you're gone? We hardly ever see a hand go up in our client orientation meeting. And at that meeting, we have a nice collection of reasonably intelligent people, and none of them has ever asked about what the fees will be after they die. So all of our training is reactive. And something happens, and then we try to do something about it. And at death, it's the attorney who's in control of that process. The attorney is going to explain to the family member what's going to happen, what the fees are, etc. And of course, we didn't set the system up intentionally, but it's set up so that everything that they need to learn about what to do it, how to pay for it, is after the client died and they're in the grieving period. So for grieving people, obviously it's very difficult to learn new information. You know, if it's a spouse, it's very difficult that they just lost their life partner. And if the client's goal or snapshot is that things will go smoothly for those who come after them, then that's a gaping hole if they don't know what's supposed to happen if they come in and try to learn in the grieving period. And at that point, they have no leverage. They're being told this is what to do, and here's how to do it, and this is what the fees are. So we suggest to people, find out now what it's going to cost. That's what we believe would be a better plan. So the traditional approach is reactive. In our approach, what we're trying to do is prepare. It's a proactive approach, and that's what we're about. So our process is called the 3-step strategy. This would be a way to develop a plan that works. We have develop your plan with counseling-oriented planning partners. 2, commit yourself and your loved ones to a formal continuing maintenance and education program. And finally, secure appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. So appropriate assistance is something that each of us applies individually. When we get to that stage, the client has expertise in the family, advisors, professionals, the firm, or whoever will work together. And the key word is appropriate. They need to decide what part do I do, what part do other people do, etc. So we tell them to build a team after the death has occurred, and that's how you build true peace of mind. The develop your plan is the first step, and partners is plural because the lawyer can't do a plan by yourself, nor can a financial advisor. So now what passes for estate planning in America today is 85 to 90% mere word processing. And there are 3 types of plans. There's a single person's plan. This is in typical planning. And for a married couple, a plan under the number Congress has said is rich. And then over that number, you need a specially designed trust. So, of course, we're all about counseling. So what happens is we ask the client, okay, what do you want to do? And there's usually silence. And the attorney is supposed to design the plan for the client, so we start asking a bunch of questions and ask about the assets. So we'll ask things like, what do you say your home is worth? What do you think your home is worth? And one of the spouses usually makes a mistake of trying to answer, and the other will say, oh, you can never get that much. But, you know, the attorney makes another try, asks, finally, if you added everything together, what's the total? Clients say, I don't know. So why do they say, I don't know? Either they don't know because they just haven't added everything up, or they don't want to tell an attorney how big the estate is because the attorney is going to base the fee on the size of the estate. Well, we tell them ahead of time that is going to happen. Directly or indirectly, the fees are determined by the size of the estate because there is no other effective system that has been developed. As you know, the only fee that doesn't depend on the size of the estate is hourly billing. And every study of hourly billing that we know of shows 2 things. 1, the client doesn't believe the professional spent the time that they billed for. And 2, even if the attorney spent the time, the client doesn't believe what they got was worth what the final bill was. So people might hourly bill, or they bill toward a certain percentage of the estate. So that's why we say work with a counselor rather than accept word processing. And I will reveal the classified trade secret that attorneys have computers. And if a client accepts that, that you're just going to get the word process form document, then the harder question is, why are they working with an attorney in the first place, or a professional? So if an attorney can't tell the client the value of their services, they shouldn't be in the process with them. You know, when you have things like LegalZoom and Quicken Family Lawyer, attorneys don't like to hear stuff like this because they say clients don't know how to choose the form. But, you know, most people work with an attorney because it's the reasonable thing to do. But they are likely to get the same kinds of forms from the legal office as they do on that software. And we think there ought to be some value, and it should be from counseling. So I will let Frank begin to explain what that counseling looks like.
So here are a few things, the personal planning goals we cover with clients in our counseling and design session. So first, let's talk about catastrophic illness protection. Now, in our meetings, we ask how many of you have an opinion if you do have a catastrophic illness or at the end of your life about whether you'd rather go to a nursing home or stay in your own home. Of course, everybody raises their hand. Now, we don't ask the clients what their opinion is, just whether they have an opinion, because clients aren't going to put that opinion in a document anyway. If we gave them a blank sheet of paper and we asked them to write down what they want to have happen, what do you suppose we get back? Well, we get back a blank piece of paper. You know, at best, the client is going to sign a healthcare proxy. And in that document, there's a list of powers, like it's okay to sign me into the hospital or move me to a nursing home, but it doesn't say which one the client wants. That's okay, because they've all talked to everybody or someone about specifically what they want. Well, obviously, we just left the world of reality, because in our experience, most of them don't, because most people don't ever have that conversation. So, you know, here's heresy for a lawyer, but this is what we think, and see what you think. We think people would be better off with a great conversation with their family about those issues and no legal document than the farce of a legal document that doesn't give direction and no discussion. But in the ideal world, wouldn't the client be better off if they had both the document and the conversation? So then the next counseling issue is something we call remarriage protection. Now, most people don't like to talk about this because it has to do with what happens after one of the spouses dies. But many agree that it's not about the trust between them. It's about the new person, the new male or female, husband or wife, that their surviving spouse might remarry or marry. And clients usually agree that it's about the influence that this third party has, not about whether they're a good person or a bad person. Many people have a story that there was an agreement about how a couple was to share with their children, but it went the other way. The point is that there are some nice options that people can pursue, but aren't in most plans precisely because nobody talks about it.
I'm going to share a story for creditor protection. And before we start this one, I want to make it clear that there's no creditor protection by doing a living trust that you create for yourself. So a client can't take their assets, put it into a living trust, and hide those assets from their creditors or bar them from getting to them. So in this story, I have died. And as a typical person, my goal is to get my assets to my husband. So I've died. I give my assets to my husband, Paul, and several years later, after my death, he's out driving. It's one of those early mornings, you know, the road's slick, he's driving a
Christine?
little bit too fast, he loses control and stuck. Yeah.
I just want to make sure, could somebody say, did everybody hear what Christine just said? Because for me, it sort of phased out. I want to make sure everybody's able to hear what she said.
It's a little in and out.
Yeah, Tom, could you say whether you heard everything of what Alicia said?
Christine.
I'm sorry, Christine. Yeah. Well, okay, let's just go on. Go ahead, Christine.
That's okay. I can repeat some of that. So what I said at the beginning is a person who creates a living trust can't put assets into their living trust and hide them from creditors. And this story is what we call the school bus story, to demonstrate how we can plan for creditor protection. And so I die. My husband, Paul, after my death, several years later, goes out for a drive, and he goes too fast, loses control, slams into a school bus with little children in it. And what I was saying was, we're not talking about a bill-paying creditor when we're talking about creditor protection. We're talking about catastrophic lawsuit creditors. And obviously, these are the wrong people to hit, these little children. Because in an instant, the car can slam into the school bus and everybody's life has changed, and there's not going to be many people on Paul's side. In fact, he himself is not on his side. So I want to make sure everyone got the facts that I gave you, that he was driving too fast. So it's his fault. and he's going to lose that lawsuit. And that lawsuit's not small. It's going to be hard for him to come up with enough money for injuring little school children. And a judgment like that could be over $100 million, of course. I have another sad fact for you, and that is I don't have $100 million to give him. So there's a lot at risk. There are several ways I could have planned my estate to give my assets to my husband, Paul. The first one is, like most married couples, we could have owned everything jointly. So when I died, who gets the assets? Paul did. And then automatically by law, he has them. There's no probate. I die, it goes right over to him. Now, whose name are on the assets at that point? They're in his name alone. Then he hits the school bus. The creditor has a judgment against him. How many of those assets are at risk? All of them are at risk. If we were to back up and do it over again, the second way I could have planned, I had everything in my own name, and when I died, everything went through my will. My will was a typical will, and I gave it all to my spouse. Sometimes it's to my spouse and then my children. So when it goes to probate, it goes to Paul. It's in his name, and then he hits the school bus. How much is at risk? The whole thing. A third way a lot of couples own assets and a lot of assets are controlled are beneficiary designations, as you all know. So there could be life insurance, IRAs, 401ks. If we take an easy one, life insurance, if I was a typical American couple, my beneficiary would be my spouse. So when I die, that insurance policy was paid off in cash and is sitting in an account in whose name? In Paul's name. So when he hits the school bus, again, how much is exposed? All of it. So the fourth way I could have planned is my favorite. I do one of those living trusts, but it's a bare bones trust, and I set it up just to avoid probate. And when I die, it actually works by some twist of fate, and it does avoid probate. Everything goes from me to Paul without probate, but when it's transferred, whose name are the assets in? Well, it's either in Paul's, or if he is really sharp, it's in his own trust, the one he created for himself. So how much protection is there? Again, no protection, because either it's in his own name or it's in his trust, which he can't shield from creditors. And so how much is exposed? All of it. So I'm going to do a fifth way for planning. Pull me out of the grave, and I set up a trust for Paul, and all of my assets go into that trust, and the terms say Paul can get in and out of that trust for anything that he might need, but if he hits the school bus, the creditor can't get in there. So we ask clients, how many of you would like to leave your property to your loved ones that way, protected from their later creditors? It's just one paragraph. It's word processing. The document doesn't make it work. It's how you own your assets, and the counseling around the use of that document, that's the key. And most clients have never been asked that question before. That's the counseling gap. And how are they going to design a plan if they don't know the options? Clients are doing things based on what they're told they can do, and that would be the value of the professional, obviously, to give them the options. There are a few trade-offs for this kind of protection, and most of them the family decides that's what they want. Most of the time the family decides that's what they want, or some variation. So for divorce protection, most people have the wisdom that some people get married and later they get divorced. This is not the client's marriage, it's the loved ones they give their assets to, like the kids, and then they get a divorce. So we ask them, would you like to assure that if your loved one has a divorce, that the property you leave them stays with them rather than going to the now outlaw, and they can make that decision themselves.
So for values promotion, you know, many of you have kids or you've been kids, and of course all of our clients have either been kids or they have kids. And typically when a parent goes out for an evening, they leave a long list of instructions for the babysitter on how to care for their children. So, you know, I've had that experience myself. My wife and I went away for a weekend. We left a long series of instructions, 4 pages, single-spaced. My wife's mother took care of the kids that weekend, and a few years later, she gave my wife an envelope with those instructions back, and she opened it up eventually, and in there were the 4 pages single-spaced. You know, many of our clients have that same experience, but there's one thing that we left out, and that was what was supposed to happen if we didn't come home. If we go out for an evening or away for a weekend, more clients leave more instructions when we go out for an evening or for the weekend than we even attempt to leave when we're gone for a lifetime in our estate plan. So we work with them to kind of establish these instructions, and that's counseling.
So the second step is to commit yourself to a formal program. And there are 3 types of changes that the formal program addresses. So there's 3 types of changes in an estate plan. Personal and financial changes in a client's life, changes in the law, and changes due to learning. Earned wisdom means the school of hard knocks. Don't touch the oven when it's hot, but the kid does. And learned wisdom is, what you learn from someone else's mistakes. So all of those factors go into changes. As far as personal and legal are concerned, many clients don't own the exact same assets they did 5 years ago and aren't at the same financial institutions with the same advisors sometimes, nor do the assets have the same value. How would a client know if there are changes in the law that they would need to address? So, how would they know there's been a court case affecting the school bus protection, for instance? Usually they're totally helpless on that front and completely dependent on the lawyer, but you can see that the lawyer is equally helpless about changes in their personal situation. We don't know if, they've changed brokers, who's gotten married or divorced, who's not getting along, and now is on the outs, and so forth. So if a client buys a plan, how long do you think it will last? Well, what we do is exchange commitments with clients and agree that we're going to revisit the plan every so often. A lot of legal changes happen, and we read the cases and statutes, and we commit to coming back to the plan with them every other year. A colleague of ours actually did a study, an informal study, with the people that came in to do planning with him, and it was an average of 19.6 years since the clients had last visited their plan. And if they had a financial advisor, that number actually cut it to less than 10 years because you remind them. So we have an accountability system so that they're not taking 10 to 20 years. And every other year, our clients come into a group meeting, get the changes in the law, and we give them some education on it. Then we have them sign a restatement of their trust and ancillary documents. And then prior to the meeting, they fill out an estate planning review worksheet that we provide, a summary of the personal provisions they have in their documents, so they can update us on changes in their personal situation before they come in and sign. And obviously they do that throughout the year as well as they keep in touch with us. Right. In addition, we need to know if they've changed their assets. So you see the financial piece there. And they update that, they update us on that. And so every spring they send in information. It's usually easy for them because it's around tax season. In fact, we just return reports to clients at our annual client meeting with any new account the clients have and how it's titled, as well as the updated values. So what happens is I'm going to do the best plan I can do today, but next year I've made improvements. So the first client gets the bells and whistles, but next year what happens to the plan? If it's sitting on a shelf and they intend to pull it out but didn't, then it's outdated. So the third step is securing appropriate assistance that we talked about a little bit. Most people shop by the cost of the documents. So you can call every place to get the cost of an IT, but most people never ask what's the cost of updating. So usually the cost is the failure to update, and the family finds out after the client is gone what the cost of not updating is. So last is the cost after death there, which has the 2 parts, the cost of changing the names on the assets, and 2, the cost of preparing the returns. This is the cost that people never talk about. That's what we've been discussing. People don't discuss with their estate planning attorney how much it's going to cost after death. So if we're to control the cost after death, it requires full funding, and that means putting things in the name of the trust. So a trust with everything in it is what we call fully funded, and one without it is unfunded or partially funded. And you have to do this to avoid probate, and tax planning and personal terms are require full funding. So we have to be satisfied that the client is fully funded, and that's why we do the yearly funding update. And why I like trust better than wills is we know people want to avoid probate, and it motivates people to get all the assets together and fully funded, which means the trust instructions apply to the assets. So we have a proactive engagement approach. We have a fee agreement that says what the fees and services will be after death. We can do that in advance, but of course it's unethical to require, that we be engaged by the family after the client is gone, and it's the client's helpers who choose whether to hire us after the death occurs. But as long as the client stays in the maintenance program, we know things will be in good order, and we can agree to a lower fee on the back end. So we want to be like Paul Harvey and tell you the rest of the story. What are the rest of the fees? If I get disabled, what are the fees? What is done? How do I pay for it? And who does it? After death, who does it? How do they do it? How much does it cost? If a client goes to a living trust attorney, they should especially be asking what are the fees if it turns out there is a probate. Because if you don't keep the assets in the trust, you end up with a probate, as most of you know. And odds are against the client if they aren't working with someone with an accountability program. Then they'll both have a trust settlement fee on the assets that are controlled by the trust and a probate settlement fee. So it's actually more complicated if they do a trust and don't do it well. Traditional fees are 2 to 3% of the estate. This is settlement fees. And then standard living trust fees, in our experience, does save some money, but it's still at 1.5 to 2.5%. With our plans, it's 1 to 2% of the overall cost. So this slide is a little bit confusing because the difference is that the first two don't include what you paid for the document. Our fees of 1 to 2% include all the fees. So if you're married, you pay the fee up front, the updating fee, an estate settlement fee after the first spouse dies, then the surviving spouse is paying some updating fees, then the surviving spouse's estate settlement. So the smaller the estate, the higher the fees because there are some things minimum you have to pay. But we charge to develop the plan roughly 0.5% of the entire estate up front. And there's a minimum and a maximum. People usually don't like to pay more just because there are more zeros on their assets. But if they did a school bus trust, then there are more assets protected, and that's the value of what we protected. That's the way we look at it. So then there's a maintenance program, and that fee right now is $495 per year. And after the client dies, we start with the fee at 1.25% of the size of the estate. However, if they have held up the commitments in the maintenance program and if they participated, we tear up that first agreement and we make it 0.75%. So typically when a client goes to an estate to do an estate plan, they can get an IT for less than $3,000, but it's just an IT, and they're only getting a stack of documents at the front end. A lower front end means the back end is more expensive in our experience and statistically. So we get everything we can done in our program during the client's lifetime, so the overall cost of the plan is less. Our front-end fees are paid in increments at the separate meetings in our development process, which we flesh out a little bit more in our small group orientation meeting. So as I discussed before, there are a lot of options on how to create an estate plan. The joint tenancy, simple will with a testamentary trust, etc. The final option in this is a comprehensive set of instructions established in our Heritage Design Protocol using a living trust, powers of attorney, healthcare proxies, trust affidavits, etc. And we prepare those for the clients as well as doing the full funding. The places where it makes a difference are in these 4 major estate planning challenges: mental disability, asset transfer upon death, taxation, and personal planning goals. All of these are the things that we will discuss in Part 2 on Friday, August 15th. We flesh out more of those issues that come up in counseling. So our recommendation is to pursue the 3-step strategy. That's essentially what we share with clients at our small group orientation meeting every month.
So let's talk about the opportunities. What's in it for you, how we can work together as professionals. And so, what we want to do is we want to introduce you to the era of wealth reception. So welcome to the era of wealth reception. There are three areas of planning. Basically, there was the era of creating wealth, and then there was the era of transferring wealth. To date, one of our colleagues put together was 1974, which was the advent of the money market fund for the beginning of the wealth creation era. And the reason we use that date is because there wasn't enough money to have an actual industry at that time. There was no money magazine. That came in the 1970s. At least we don't know about it, how much money there was. And Money Magazine would do surveys, and then of different money market funds. So as a client, you'd throw it in the money market fund where you get a small amount of money, and then you do research to find something else that would give you a better return. So it's the client's role in creating the wealth. Most of what our industry is about is transferring wealth. So the, second to die insurance is paid off when the money transfers, because that's when there is a tax. Charitable remainder trusts, we'll give it to charities so that it saves the taxes when the money transfers. Living trust is to avoid probate. When does that occur? When the transfer occurs. And we'll put two trusts in there to have a credit shelter trust to save taxes on the transfer. So the whole industry grew up in the transfer and nobody looks at reception. So what we're about is a plan that works, and you have a giver and you have a receiver. So the receiver, if you look at the beginning, if you look at it from the beginning and look at it with the end in mind, they have different questions. So here's the definition of what we call wealth reception. And why it works is it's a formal process designed to assure you or the client and their loved ones that their true wealth, both financial and non-financial, is fully realized, effectively transferred, and effectively received. So, beginning with the end in mind, all states want this kind of protection, as Christine discussed earlier. When is it okay? Christine, just go back a little bit. So, the questions that clients ask is, we ask clients is, okay, when is it okay after you died for the outlaws to get the money that you left to your spouse or to your children? When is it okay for the creditors that are in the school bus to get the money you left for your spouse or whatever that was? And, they always say never. So, Christine, next slide. So what are the partnering possibilities that arise with our firm's process and with you? One, we have a process orientation to address what we call the great relationship divide, and that we talk about in individual meetings with you. Two, we have the three-step strategy, and that we just described. And three, we're an intentional third-party credibility organization. We have specific steps in our process designed to put the spotlight on you as a financial advisor and transfer the third-party credibility that we can give to you. And it's a fresh overarching message with wealth reception planning because we're at the beginning, and we're starting at the beginning with the end in mind. So, the background of this slide was there was a conference, and I think it was with Alexander Hamilton, and there were 300 attorneys and advisors present. They were split up into two separate ballrooms and were asked to describe their relationship with the opposite group, and this is what they came up with. So, the advisors said, now a normal attorney is slow and they're non-responsive. BIL stands for in other words, if they have a relationship, if the client has a relationship with the advisor, the attorney always refers their client to their brother-in-law. And then, of course, the attorneys are deal killers, and they talk in incomprehensible language like they are smarter than everyone. So, okay, what was it on the other side? The attorneys were saying, well, let's see, they can be unprofessional. They're peddlers who are they're transaction-driven, and they're impatient. So this is a problem that both sides face, which is the gap between the professionals. And you as the advisor are looking for a different kind of an attorney, just like we're looking for different kinds of advisors. So we try to address these issues because we're looking for a certain kind of advisor to engage in a transformational relationship. We share with each other. Some attorneys are close to the vest. We have a really practical orientation toward planning. We talk in plain English, not this unintelligible I'm smart language. We have a team approach, and notice all the punctuation after the team approach, and that's there because the team approach means, in many people's view, I got all your clients, we work in a team, you run out of clients, and I go on to the next one, then the next one. So we actually what we were actually trying to do is to have a truly collaborative longer-term relationship where there's a mutual exchange and understanding. Interdisciplinary, our approach is interdisciplinary because we believe a plan can't work without working in a team. So how do we collaborate? We're serious about that, and what we have is an expectations. We have a communicator, a piece of a document that's a communication of both our sides' expectations. And so we actually agree with the advisors that we work with on how we're going to work. We also have this thing called an estate planning review letter, where one of the services we offer is, it's not just your job to say to the client, oh, you ought to have your plan reviewed. So we'll actually do a review for you. It's not hard for us to do, especially if you're in the practice of getting the client's estate planning documents to review them. So you could attach this to your process, and we'd be happy to review the plan and do the letter for free. We typically produce an 18 to 19 page summary of what the documents do. And so the partnering opportunities, I'll talk about in some length now. So, this is where we want to reinforce the relationship with your current clientele. When we do that, that means new business for you too. So if you want to generate new business, we could do workshops together. Very happy to do that if someone is doing that in their business. And finally, we're not after who's in charge of the client. We think the client is in charge of the client's plan, and we're happy to share control. Now, we are at third-party credibility, and this is where we have a specific step, in our process designed to put the spotlight on you. There's a long list of third-party credibility opportunities, and I wanted to give you a few. That's the 5 there. And these are specified opportunities in our process where you have a chance of third-party credibility. The first one is what we call a preparatory meeting with clients. We can train you in this meeting we have with the clients at the beginning of our process. We ask a lot of questions that normally a financial advisor doesn't ask, and you have a lot of financial questions that we typically don't ask. And this, this would give you, by learning how we do our beginning of our process, this will give you the estate planning side and potentially a bigger picture of the assets. If you do the prep meeting, what happens is you have full financial disclosure. We have clients sign a limited release of attorney-client privilege, so you have they have not given up fully the right to have attorney-client privilege, and these, by the way, are people, if they've been to Truth About Estate Planning, then they've made a decision that they aren't going to be in court, and that they're going to name things, and they want it formal, and this is their goal. Because of that, they're willing to waive the attorney-client privilege on a limited basis that allows them to share that information. Your profession has been doing this for far longer than attorneys. It used to be called fact-finding, and what we need to do is make sure that you get your supplement, or get our supplement that we need for our estate planning. So, we provide you with our supplement and some instruction on the kinds of questions that we need to get answers to in preparing for the process that the clients will have with us. Doing the prep meeting, can deepen your client relationship, and it will deepen your financial relationship because they give you full disclosure of their financial information. And it's added professionalism. I'm not saying that you're not professional. It can help cynical clients if you're doing this for estate planning. That prep meeting would take place typically at our office because it's being done for the estate planning, and you'll go over exactly the same forms with the goals and the roles that we need to get done. And interestingly, we'll get a lot better financial disclosure for us than we would if the client says, my advisor has got all that stuff, talk to him or her. Because number one, the advisor doesn't have all the stuff. And number two, it's complicated to chase after what you have, and you still go back and forth with the client to do a fully funded trust. That's our difficulty. So working with the advisor, that makes it a lot easier for everybody. So that's our first opportunity. The second opportunity is the financial strategy session. It's a dedicated meeting for you to make your recommendations. The attorney calls the meeting. That's us. We call the meeting, and it's part of our process. Here's the deal. Attorneys sell cars, advisors sell gas. What good does it do for me to build this great structure and there's no fuel? We're in the business of creating plans that work. If I'm going to work for a young parent, I'm going to make sure that there's insurance for that purpose in case the people die, and so there'll be money there to finish out the job. If there's a tax need, we need money to pay the taxes or a strategy to pay the taxes, whatever is appropriate. So there is a specific session to discuss the need. The advantage to you is that you come to a financial strategy session, and it's an amazing thing. What happens is you refer a client, and we go through a very intense process of co-creating an estate plan with the client, and we get very close. We spend 6, 8, 10 hours with the client, and we get this financial strategy session, and you've made a presentation on your recommendation, and you've got this longer relationship with them. And they'll look at the attorney and ask, what do you think? So you remember that remember that third-party credibility? Even though we met the client because of the advisor, and the advisor recommended them to us, they've been working with us, and now they trust us, and so they ask our opinion. So of course I would say work with them, work with the advisor. That's why we're all here, to make the plan work. That meeting's done in our law office. So, this screen is the financial strategy synchronizer, and here are some opportunities in a person's lifetime. We probably agree that there are 3 stages that life in a plan goes through. When you're alive and well, when you're alive and not so well, if you become mentally disabled, and if it's a couple, there will be a time that there's first the death, and there's the first death, and the survivor, and then the second spouse dies, where everything is transferred to the next generation or whoever they have designated, and maybe beyond. So we have a counseling tool we use with clients called the design template for the counseling meeting, and it's broken out into these 3 stages. This financial strategy synchronizer mirrors that design template, so when they come back to the financial strategies meeting with you at the table, we can discuss things that they might do at these stages. So we'll say, here you are alive and well, and these are where your products and services would make a difference in their lives. And if they're disabled, we'll look at those. And of course, the recommendations are customized per clients. So if you're a business owner, then you might need business owner overhead insurance. Buy-sell disability insurance or short-term disability is often available through employment. And people don't talk about it and tend not to really know whether it's good or bad or indifferent, and HR leaves you on your own. So getting those recommendations is important for people. And then at the first death, this is what happens. We have a lot of different products and services. So we take them through these things, that they might have. And it makes a difference if you're in the marital side, trust side, or the family trust side. And then after death, we're over to the next generation. So I assume we'll be able to work with that generation, and that's what wealth reception is about. So we have all these products and services that need to be discussed with the receivers of the wealth. So the third opportunity is the Heritage Design Learning Solution. It's an education program. We support clients with successor trustee training and those kinds of things. So if you have that in person, it's something you can join with the clients in, and then we're able to be elbow to elbow with the next generation. We've just had a couple of our annual client meetings where we had financial advisors come and meet the clients directly. Also in the learning solution, you may want to be the instructor if you want a chance to talk with our client base. Of course, now the unattached people are fair game. So if you can't come in and steal clients from other advisors, but if you're smart enough and you're teaching and you're generic, and you teach something that's of value to the clients, we're happy to do that. So whatever your specialty area is, or a focus of your practice, you could do a workshop, and we record things that can go for the next generation, and that can help in terms of keeping the assets under your management and so forth. Who, by the way, do you think would get that opportunity the first? People that we know the most about. So just like you, before we would put somebody in front of our clients, we'd want to know all about their process, how they work, and all those kinds of things. That's why we try to do the introductory meetings with you, to learn about your business and to discuss how we'd work together. So it's not about you sending one referral and then saying, hey, I want to come in and teach. It's about people we're committed to working with and building something together. If we haven't yet met with you, the first step is to have a meeting to get to know you and how you do your business and your process. So the customizer, the trusteeship customizer, is one where there are 3 functions of the trustees, and what we're going to do is carve out the investments so that you will be there to continue to manage the money, which is what families want us to have in their own financial advisor, not a bank trust department necessarily. The trusteeship customizer has the divided trusteeship drafting. In other words, there's different functions of the trustees, and so the trustees can be divided. And it supports the retention of the assets and plans that work. We draft the trust for divided trusteeship, and remember the school bus story. Most of the clients say, put the property in trust forever, and we divide the trusteeship. The child becomes their own trustee for most purposes, so they're going to want to have their own investment advisor. So when mom and dad have died, we ask, who's your advisor? And I have to go through with them how this is going to work. So if you're my planning partner and I'm going through it, and you've done a great job for mom and dad, then why wouldn't you want to be in that meeting? So with a divided trusteeship, we have open investments and open administration. And the only thing with the school bus is, they have independent trustees to say, no to creditors. So, it's wide open. Who's going to be that advisor that's going to help with the investments? They get a delegation of the investment authority. So there are personal protections, not just tax, and remember, because it's all locked away in trust. So, here's the trusteeship customizer. The most common function is the distribution trustee, and then the beneficiary trustees will carve out the investments. So we do have a lifetime trust, and that's not a threat to you. It's a benefit to you because the trustee is only over to say yes or no to the distribution. And so the clients will delegate the various different functions. In particular, they might delegate the investment to the advisor that they feel confident with. So fifth and last is the trusted advisor test. There's there can be a specific inclusion of your name in our documents if you pass this test. The boss, of course, is the clients, not the firm. So the parents say, work with so-and-so. That's in their trust. And I'm quite aware that you would want to be a trusted advisor, and most of you are, and well, I should say all of you are. And when I ask what is a trusted advisor, what I get from the advisors is, I'm the quarterback. I'm the go-to person. I'm the first call, etc. But we never have a client tell us that their advisor is the trusted advisor. It's a financial industry term. And even though they are the trusted advisor, our clients don't really say that. And I don't mean to be insulting, but it's something we want to address. So we have the trusted advisor test. We have here's the test. And that is, your relationship with this advisor is so strong that you consider his or her advice or relationship an asset you'd like to pass along as part of your wisdom and wealth. And so we want the client to say, you're the trusted advisor, and put your name in, and then we'll be able to tell the kids this is how our client strongly felt. And so this is an asset, this relationship with you, and that they've built up over their lifetime, and so they want to pass it along. It sets our buy pretty high, but that's what we're trying to do with this wealth reception. that's what we're all about. So here's the next step. Christine?
So we would like to have a follow-up meeting with you about how we might work together. And some of you we've had the chance to meet with, and some of you we didn't. So Alicia, in the next 24 hours or so, will be sending out an evaluation to you via email that you can choose to have a meeting with us. And that will also have a space for you to give us details so that we can get you CE or CPE credit. Like I mentioned at the beginning, if you want the full 3 credits, you have to attend the follow-up session, and our next time for that is on August 15th from noon to 2. So clients sometimes also join in on that online session because it prepares them for making decisions on their design. We have a web version for them as well that's pre-recorded, but this gives them an opportunity to ask questions. So sometimes they're there, sometimes they're not. But again, it's a more legal technical session, and we flesh out some of the counseling issues. And then you're also welcome to register yourself and or your clients for our client orientation meeting next Tuesday, which is August 12th at 6:30. Some advisors like to have the chance to observe what a client would experience outside of what we've discussed today, and see how they react to the message. So we're happy to have you at that session. And besides that, that's all we have for you, and we really appreciate you all listening, and we hope it's been useful. So I'm going to mute everyone, and if you have any questions, please feel free to ask them now. Does anyone have any questions? All right, great. Well, we really appreciate you guys coming out, and obviously we can have a conversation with you outside of this meeting, and we hope that happens. So thanks again for coming, and hopefully we'll see you or talk to you on the 15th. Take care. Bye, everyone.